This is the first seminar of the year for the Digital Law Group, but it's also the first seminar of the year for the Monash Data Futures Institute, which is co-sponsoring the seminar. I'm the Associate Director for Global Governance of the Institute. If you want to know what that means, ask me afterwards. And also it's been co-sponsored by the Centre for Commercial Law Studies at Commercial Law and Regulatory Studies in the law school. So we're very grateful to both the sponsors who have enabled us to bring an international speaker from Canberra, which may be explained in a second. So I'm really delighted that we're hosting Nora Ni Loideain, Dr. Nora Ni Loideain, Senior Lecturer, which is Associate Professor in Law and Director of the Information Law and Policy Centre at the Institute of Advanced Legal Studies in London, which is a mouthful. It's the Russell Square Centre, which Nora has run for many years now, Nora, 5 years?
5 years.
Yeah.
7 years.
And obviously, we have crossed paths in London, amongst other places. Rather than talk about Nora's research in depth, because you're going to find out about it in a minute, I'm going to introduce you to Nora and say that, Nora, you're going to speak for about 30 minutes, and then we'll move to Q&A, mainly in the room. We will give an appearance of spontaneity for the online chat as well. So, Nora, over to you, and thank you. For those in the room, the presentation appears in the right-hand corner. Thank you.
Okay, well, thank you very much, Chris. It's an absolute pleasure to be here. I have my microphone on, so can everybody hear me in the room nice and clearly? Wonderful. And I hope everyone can hear me online as well. It is such a pleasure to be with you here in Monash, and my thanks to everybody who's helped organize this, especially Chris and also Claudia. So, as Chris mentioned, I will begin this talk today. And I will be talking about the EU AI Act, but I will be talking about the EU AI Act within the specific context of fundamental rights protection or human rights protection. So that's the lens we'll be focusing on today. And I'm just trying to, where's the arrow? Pardon me, technical difficulties, everybody. One second.
This laptop's ever been used by me. If you press that.
Okay.
Oh.
Wonderful. There we go. It couldn't be a presentation about technology if we didn't have some entertainment at the very beginning. So I will be talking about the main details of the EU AI Act, but specifically in terms of how the Act has developed from its original proposal in 2021 and where we stand now in terms of the Act, which of course is not yet finalized. It is still at the very final stages. So that's something very important to bear in mind when we talk about specific provisions of the Act and specific areas of the text. Specifically, I'll also be talking about the role of fundamental rights impact assessment, which is a completely novel new legal instrument now, human rights safeguard, that's been introduced by the EU AI Act into EU law. And then at the end, we'll conclude by talking about some of the achievements that we now have from a fundamental rights perspective within the draft of the EU AI Act now in 2024. But then we'll also talk about some of the outstanding concerns as well from a human rights perspective. So to begin, to put the EU AI Act into context, it's important to note that the EU is at the forefront of digital regulation worldwide. This is particularly evident in the significant influence of EU data protection law. I don't know how many of you here have heard about the General Data Protection Regulation. I see a lot of nodding heads. But this has been a very influential piece of legislation, considered the watermark in various jurisdictions across the world in terms of standards and safeguards to be met. And it has shaped data privacy laws and practices internationally and even beyond Europe in that respect, in the US, many countries across Africa, for instance. And the horizontal risk-based rules approach to regulating AI in the EU AI Act is also landmark because it is the world's first piece of comprehensive legislation to govern AI systems. And already it's having influence in policymaking debates on AI and practices worldwide as well. We see the influence of this high-risk AI model and also a focus on red lines or outright bans or prohibitions on certain AI practices taking place in jurisdictions the world over, including Australia. In the review of the Privacy Act here, we've seen a focus in the Attorney General's report and also more recently in the past week by the Minister for Science and Industry here talking about the fact that the possibility of harder regulation or prohibitions hasn't been dismissed entirely in terms of what future governance may hold here. So this is just one simple example of the influence that the EU AI Act is already having, despite the fact that the legislation itself hasn't even been finalized. So, as I mentioned, we'll be talking about the EU AI Act within the human rights law context and talking about the fact that it's a novel ex ante regulatory tool, which means that it's going to be building human rights into an AI system from the very beginning before its deployment, not an ex post safeguard regulatory tool. And that's particularly important when we think about AI systems now, which are increasingly complex, have many different individuals involved in the chain of how AI systems are delivered in terms of the data sets, the design, the modeling, who provides them, who distributes them, and also who deploys them. So ex ante impact assessments have become more significant now than ever before, because it's so important to get these safeguards embedded in these systems from the very beginning, because it's incredibly difficult or outright impossible to put them in a retrospective way. So more now than ever before, ex ante regulatory tools are very significant. As I mentioned as well, the fundamental rights impact assessments were not part of the original text of the EU AI Act when it was proposed in 2021. It was a human rights safeguard that emerged as one of the major revisions of the Act, particularly through the efforts of the European Parliament and also through the efforts of a number of very influential civil society bodies. So it was adopted during 3 years of very closely scrutinized negotiations in the co-legislative process between the European Parliament and the Council of the EU, which represents 27 member state governments, otherwise known as the trilogue process. Of course, that used to be 28 member state governments, but we're not going to go there right now because that's a very sensitive topic. Maybe we could chat about it afterwards. But the fundamental rights impact assessment and a number of major revisions introduced by the European Parliament's review by the proposal, it was responding to a number of serious human rights concerns raised by EU regulators in the UN, civil society, and academics, particularly that the proposal was not striking the right balance between its very complex combination of very different types of EU law, from EU product safety regulation, consumer protection law, data protection law, and also fundamental rights protection. The initial proposal was much heavier in terms of its substantive provisions regarding EU product safety regulation, for instance. So in terms of the impact on actual users or individuals affected by the measures and actual communities that will be affected by these powerful AI systems, it was very much criticized for actually leaving this impact on users and then, of course, their human rights as well as a blind spot. It was a consideration that a lot of stakeholders thought was very much overlooked in the initial proposal in 2021. So where does the EU AI Act itself originate from? It's very important to remember that the EU AI Act is just one in a very rich tapestry of many other pieces of legislation that has just emerged in the past 5 years in the EU. So this started out as part of the EU strategy for data in 2020 to enable Europe to become the most attractive, secure, and dynamic data agile economy in the world. So very much a focus here on innovation and the economy, and then also a focus on bettering the lives of citizens. But again, I mean, not a heavy focused here on fundamental rights or those more ethical considerations. This was followed then by a white paper shortly afterwards. We had a consultation, and then the consensus was reached that one of the ways in which this was going to be achieved was through the regulation of AI at the EU level. Then in 2022, we had the announcement of Europe's digital decade between 2020 and 2030. And in that policy programme decision, in Article 3.1, there was a commitment made by the EU institutions and member states that they would cooperate to achieve the following objective at the EU level, so the implementation of EU legislation, which again would be to promote a human-centered and fundamental rights-based, inclusive, transparent, and open digital environment. So here we see an increasing focus now on the mainstreaming and the protection of fundamental rights, which is encouraging and a step forward from, for instance, that blind spot that I mentioned in the 2021 proposal. So this was the time when that mention earlier on about binoculars could have come very useful. We have here a very complex image in terms of all the various different types of areas that the digital decade of policymaking in the EU is covering. You don't just have AI, you have data governance, you have the hardware, the software involved in these AI systems, semiconductors, chips, we have the regulation of online platforms. This is a very rapidly emerging and very complex legislative system that the EU AI Act is forming just one part of. Then also in 2022, we had an increased focus again on human rights or fundamental rights. We had the Declaration on Digital Rights and Principles that was announced. Now, this is a non-binding article. It doesn't have any legal effect. So there were many commentators, including myself, that were quite skeptical about the actual need for the publication of this document. But given the plethora of legislation and policymaking and investment in AI and innovation and its regulation in Europe, it was actually quite encouraging to see the articulation again to the commitment to fundamental rights in this document, explicitly noting as well in the document that AI should serve as a tool for people with the ultimate aim of increasing human well-being. More importantly, in terms of making fundamental rights protection a reality, it makes a reference to the safeguards to ensure that that trustworthiness actually takes place. So, as I mentioned, it's very important to remember that the EU AI Act is part of a very rich tapestry of a number of different pieces of very landmark legislation, from the Data Governance Act, the Digital Services Act, the Digital Markets Act, the Data Act, the CHIPS Act, the AI Act, which is not yet in force, but is expected to be before the end of the summer. And it's important to note as well that these have all been implemented and drafted at a comparatively very rapid pace. I mean, you see many other jurisdictions around the world still looking at the governance of AI on voluntary standards in terms of that basis. So these are all very significant frameworks that are going to have to be applied and considered in terms of their compliance together if they're going to be properly complied with and properly enforced. So what was the rationale behind the EU AI Act specifically? It was stated that in its impact assessment as a piece of regulation, the European Commission stated that it was necessary for the proper functioning of the single market. So its legal basis is primarily as an internal market measure to create harmonized rules on trustworthy AI throughout the EU. And this justifies its need for regulatory intervention at the EU level because of the cross-border nature of the development and use and deployment of AI systems, that large-scale data, all those data sets, the applications that mean that these are objectives in terms of the regulation that can't be achieved at the member state level. And that's the justification that warrants the law then being adopted at the EU level in terms of ensuring a level playing field. But again, quite significantly, we see this reference here to the protection of European citizens. But it's important to stress that in 2021, when we had that proposal, all of the discussion about the importance of protecting fundamental rights or human rights was in mainly the explanatory memorandum of the first EU AI Act proposal, and there was no actual reference to the Charter of Fundamental Rights, which is the EU's Bill of Rights, and the actual text, which is the legal binding section of the EU Act proposal. So there was a lot of concerns that we had that omission or that blind spot. So where are we now on the EU AI Act? Well, we had a political agreement reached in December 2021 between the European Parliament and the Council of the EU. This was a very significant milestone. We reached a deal on the technical details of the AI Act at the beginning of this month in 2024. So this is as hot off the press as you can get, everybody. But what's very important to be mindful of is to know that while there are technical details and we have a political agreement and there are leaked versions of the AI Act floating around, it's important to remember that we don't actually have the official text of the finalized act yet, but we are expecting to have this by April, possibly a little bit later, because this has been a very controversial piece of legislation, but also there's a hard deadline to when this needs to be finalized because we have the elections for the new European Parliament coming up in June. So it is expected that we will have the final official text of the EU AI Act by June at the very latest, but possibly April. So needless to say, for a lot of you I know who are already familiar with the proposal, that this is an incredibly lengthy and complex piece of legislation. It is over 250 pages long. We're not just talking about the explanatory memorandum of the Act, we're talking about its main text, which has many annexes as well to the text, and they are just as complex and also as prescriptive as the text itself. The legislation is divided up into 12 different parts or titles. So in terms of what we'll be focused on mainly here today, we will focus mostly on the fact that we now have much more prescriptive human rights safeguards for high-risk AI systems. And then we'll also be talking about some of the red lines or the prohibited certain AI, the prohibition of certain AI practices that has made the EU Act so landmark and so controversial. So it's very important to identify the players, the key roles that will be played in the EU AI Act. So first, in terms of providers, the scope that they fall in within the EU Act is that they are the people who are placing these AI systems on the market, putting them into service. A major addition to the EU AI Act proposal over those 3 years of negotiations is that these providers now also include providers of general purpose AI. So those large-scale modeling dataset systems, those chatbots, generative AI, they now fall explicitly within the scope of the EU AI Act. And that was quite a significant amendment that took place after the European Parliament's review of the legislation. It's important to note that providers of these AI systems are still subject to the EU AI Act, even if they're not established or located within the EU, for instance. It also applies if they're in a third country, like Australia, for instance. The Act also applies to the people who deploy these AI systems. So those that are established or located in the EU, but even if they're not established in the EU, providers and deployers, if they have output produced by their systems that's used in the EU, they also fall within the scope of the EU legislation as well. So this draws a lot of parallels with the quite far-reaching territorial scope of the GDPR as well. But quite significantly, we need to talk about what's falling outside of the scope of the EU AI Act from a fundamental rights perspective. And there are some very notable carve-outs for national security, military purposes, and also international law enforcement operations. Now, this very much falls within debates about what falls within the scope of EU law. And traditionally, competences of member states have always very jealously guarded the area of national security. And this is part of an ongoing debate because explicitly under EU treaty law, Article 4.2, we have a dedicated provision that says that all matters are the sole exclusivity of member states. However, within EU data protection law and some landmark judgments by the Court of Justice of the EU, we are beginning to see encroachments into the area of national security. So this is very much an area to watch in future in terms of how the EU AI Act could be challenged in future or how it could be amended by the European Commission. So what we do know, based on the versions of the text available to us so far, is that AI systems that will be excluded apply to military, defense, national security purposes. Also in terms of AI systems used by public authorities in third countries. So any cooperation that Europol, for instance, would have with bodies such as the UK Home Office, for instance, in terms of their use of AI systems for an investigation, a cross-border investigation and law enforcement within the EU, the FBI, for instance, AI systems that could be used by any of the UN agencies, they are all falling outside of the scope of the Act. On a more positive note, from a fundamental rights perspective, it's quite significant that the text now explicitly acknowledges that the new piece of legislation will not affect EU law on data protection, on e-privacy, and that will also include the judgments of the Court of Justice because it's EU data protection law as a whole. And this is very important, for existing complaint and oversight and remedies measures that we currently have under EU law when it comes to the processing of people's personal data, which is also very significant when it comes to AI systems. So in terms of the material scope of the AI proposal, the latest versions now state that it has been adopted to improve the functioning again of the internal market. But again, we now have explicit references in the text to the protection of fundamental rights as enshrined in the Charter. This is very significant because We know that rights in the Charter, such as privacy, data protection, and non-discrimination, are gradually being evolved and developed by the Court of Justice in its case law. So it's very significant that we now have an explicit reference to the Charter in the main text of the legislation. And then in terms of its material scope, we now know that, yes, we've got harmonized rules for the AI systems that are being placed on the market. Significantly, the AI Act also sets out those red line prohibitions that we're going to talk more about in a second of certain AI practices. We have specific requirements for high-risk AI systems. We have harmonized transparency rules for certain AI systems. There are very prescriptive rules on market monitoring, market surveillance, governance, and enforcement. We now have harmonized rules for the placing on the market of general purpose AI systems as well. And we have additional measures to support innovation within Europe, and especially a particular focus on small to medium enterprises, because a lot of the concerns underpinning the legislation is that the EU AI Act wouldn't stifle startups and AI developments in terms of AI innovation within the EU. So this is something that was lobbied on very significantly in terms of the framing of the Act and how prescriptive it should be. Now, I haven't suddenly become very artistic in this presentation. This is a reflection of the red lines policy narrative that was established by civil society and EU data protection regulators, or the prohibitions of certain AI practices, which has been a very significant addition to EU law. So in terms of those prohibitions, it's very important to outline those which are absolute prohibitions, but then very significantly for fundamental rights protections, which of those prohibitions are actually not absolute, which of those have exceptions and now have qualifications now under the proposal. So the first absolute prohibition is on AI systems that manipulate human behavior to circumvent their free will, specifically subliminal techniques beyond a person's consciousness. And the devil is really going to be in the detail here of a lot of these prohibitions, because we see quite an interesting threshold in terms of when this would take effect. So this is when it would cause an individual to take a decision that they otherwise would not have taken, to cause that person or another group of persons significant harm. So a lot of this will turn on those thresholds of what constitutes significant harm, for instance, or what is considered that reasonable risk, or what is high risk or significant risk. It's very hard to capture an image of brainwashing. So I don't know how many people here have seen The Manchurian Candidates, but I'll apologize to those who prefer the original with Frank Sinatra. But again, that's something we can discuss afterwards. Another absolute prohibition is the biometric categorization systems. So any AI system that would exploit the vulnerabilities of a person or group due to their age, disability, the specifics of their economic situation in terms of distorting their behavior. So these are very significant absolute prohibitions, and it's very welcome from fundamental rights perspective that we have that clarity there for those particular AI systems. But it will be very important to pay attention to how they are applied and enforced in practice in terms of those particular thresholds, like that test of significant harm, for instance. In terms of biometric categorizations that categorize people based on their biometric data, there was a lot of debate and pushback in terms of the lines to be drawn around this prohibition. And in the end, it wasn't absolute. There are exceptions to this. So this would be any system that would categorize people based on their race, political opinions, trade union membership, religion, philosophical beliefs, sex life, sexual orientation. So this is something that is often that could be deployed perhaps on a regular basis by certain public authorities when it comes to certain controversial issues being debated or protested at a societal level. But then we have a significant qualification here in terms of how it can apply to law enforcement. So this is quite significant. All of these qualifications that fall within the scope of law enforcement, they will now be subject to all of the protections that apply to high-risk AI applications in Annexes 2 and 3 of the EU AI Act. We have a ban on untargeted scraping of facial images from the internet or CCTV footage to create facial recognition databases. I don't know if any of you have heard of a New York-based company called Clearview, but this was very much invoked as a result of the controversies and the sanctions that have been issued against their collection of untargeted scraping of facial images and the fact that they were in breach of various EU data protection laws across the EU, particularly the lack of informed consent from anybody who was affected by those systems. We also have a ban on emotion recognition, but this is quite significant because of two very major qualifications to this type of ban. That ban only applies to the workplace and educational institutions. And even then, there's also a caveat there that it could be used for safety or health purposes, which means that emotion recognition systems could be used in some of the most sensitive areas by public authorities, including border control and policing, for instance, where the fears of their misuse and abuse are actually at their greatest. So this is definitely one of those outstanding concerns under the EU AI Act. And it wouldn't be a presentation on anything to do with the regulation of AI if we didn't have a reference to Minority Report. And I will be yet another academic who uses this as a very clear illustration of the fact that we have a qualified ban now as well on predictive policing. We have this narrowed down now in terms of the fact that there shouldn't be risk assessments of people made to predict the risk of them committing a crime. Unless, of course, this is going to fall within the scope of law enforcement and there's some objective evidence there that can support their link to criminal activity. Again, in terms of predictive policing systems, any of those that will be regulated under the AI Act will now be subject to the protections of high-risk AI systems. So very important that there's been so much focus on amending that section, Title 3, on the protections of what will be there for the high-risk AI systems. Which brings us to the fundamental rights impact assessment, which was one of the safeguards that was introduced to deal with the fact that we now have so many powerful AI systems falling within the scope of what constitutes high-risk AI. So the fundamental rights impact assessment, which is currently under Article 29A, let's see if it's still Article 29A in a couple of months' time. It's a very detailed provision split into 5 parts. Very significantly, we have a much more narrower scope for fundamental rights impact assessments compared to data protection impact assessments, which I'll discuss in a second. But what's also a very notable carve out for high-risk AI systems is the fact that they will not be applied to the area of critical infrastructure. And critical infrastructure covers a vast number of areas in terms of what would fall under a lot of future developments of smart cities in future, regarding amenities, regarding any data-driven AI systems there for monitoring resources, which will become much more significant development in future in terms of sustainability. And it's quite an unfortunate carve out from a fundamental rights protection perspective, because a number of those critical infrastructure systems are collecting data that may not necessarily be classified or fall under the scope of personal data, which means that they do not then get subject to the requirement of a data protection impact assessment. So this is quite a notable loophole for fundamental rights impact assessments, and one that civil society have raised a lot of concerns about. Which then brings us to the question of, well, generally, subject to all of those exceptions and restrictions that we will find under the EU AI Act when it is published, what generally constitutes an AI high-risk system? So we have 2 sets of conditions under what is currently Article 6 of the EU AI Act, that it's an AI system intended to be used as a safety component, a product falling under EU law in Annex 2 of the EU AI Act. The product itself is an AI system under the EU law in Annex 2 and requires a third-party conformity assessment. So depending on the different requirements and assessments in other provisions of the Act. All AI systems in Annex 3 are considered high risk, but of course we know we already have exemptions to fundamental rights impact assessments there because critical infrastructure has already been taken out of the scope. So this is a very significant element to remember about the EU AI Act. It is riddled with exceptions and restrictions throughout all of its provisions. So the devil really will be in the detail when the final official text gets published in a couple of months' time. So we also know from an amended provision to Article 6 that AI systems will be considered high risk if they're considered to pose by the providers a significant risk to the harm to significant risk of harm, pardon me, to the health, safety, or fundamental rights of natural persons. And again, this is going to be a very interesting threshold in terms of how that gets interpreted by providers as to what constitutes significant harm and whether a high risk system falls into that category and then is then subject to all of those safeguards, for instance. A system is always considered to be high risk under the EU AI Act if it performs the profiling of natural persons. So that immediately should place a lot of those systems that we've just mentioned that fall under those exceptions of the outright bans or prohibitions into a high risk AI system. Even if a provider decides that a system doesn't fall within that category of AI high risk, it's also significant that they still have to register the product or the service before it's placed on the market, which means then that there will be documentation of the existence of that company, the fact that that product has been put on the market in the EU, and this documentation will be with various domestic authorities and also on the EU database as well, subject to various restrictions. So in terms of what covers high risk AI systems, pardon me, for the fundamental rights impact assessment, the scope is much narrower than a data protection impact assessment that will cover public bodies, the private sector when they process personal data and where there's a high risk to the protection of personal data. This, on the current face of the legislation, will be restricted to bodies covered by public law, so a very public law context in terms of the delivery of any public services. Also, private operators providing public services, so public-private partnerships, for instance, in terms of health, education, and law enforcement specifically. It also has been extended, and this was a very welcome amendment from the European Parliament, to operators deploying high-risk systems for assessing creditworthiness and risk assessment in life and health insurance. So these are quite significant areas where people are concerned about the encroachments on their rights in terms of non-discrimination, the opacity of credit scoring systems. So it's very welcome that we have this addition and that we're going to have a fundamental rights assessment that has to be undertaken before these systems are deployed. But it's very important to remember that this is a much more narrower scope than what we currently have under the data protection impact assessments under EU data protection law. So what must be assessed if you have to undertake a fundamental rights impact assessment? Well, you have to provide a description of the deployer's processes in terms of how it's going to be used in line with the intended purpose. So this is to prevent against its misuse or abuse or its repurposing. And this all goes back to the principle of proportionality in terms of the fair balancing here between its use, public interests, and individual rights. There should be a description of the period of time and frequency in which the AI system is intended to be used. So to give the example of the pandemic lockdowns and the easing of restrictions, would it be proportionate to have AI-powered drones that are monitoring the social distancing between individuals every hour of the day? Or would we only be employing them, for instance, if COVID-20, touch wood, had gotten to a stage where it was now subject to a new vaccine, and we only needed to deploy those sorts of surveillance systems if they were ever necessary in terms of making sure that people weren't interacting together when we had no vaccines in place, for instance, or where we were trying to maintain safe social distancing. The categories of natural persons, who will be affected? Who will be the people affected by this AI system? And more specifically, who will be the groups affected by this AI system? What will be the specific context and what will be the specific harms that they could be subject to? What human oversight measures are going to be in place to make sure that there's oversight of all of these automated decisions and recommendations and profiling systems that these AI systems have? What will be the measures taken if there are any risks that do arise from these systems? How will they be mitigated? Ideally, how will they be prevented? But there is also the given that there will be certain systems that we already know of in practice, such as the use of facial recognition, which has shown difficulty in identifying people of color and also females. So knowing that there are certain risks already established in certain systems, there should be mitigating factors already built in. So within the context of, say, police use of live facial recognition, you would have questions of, well, what criteria will be put in place by a police force in terms of when it can be used? What rank of police officer should be able to access that information? Who should be authorizing it within a police force, for instance? Should it be someone at a very senior level? And if it is, who gets access to the administrative details of that system? Who can delete information from that system or change the settings on how a particular AI system operates, for instance? And will there be independent testing from an internal auditor? And if there is, will there be any contribution or participation from the affected communities? What specific types of external oversight will you have? So it will be very interesting to see how much of this detail will be in these fundamental rights impact assessments, because the requirements are quite prescriptive in the legislation. It's looking for detail on internal governance arrangements and complaint mechanisms. It's very important to see in the legislation that there's an acknowledgement that we already have data protection impact assessments, and that a fundamental rights impact assessment can build on data protection impact assessments which have already been undertaken, which have been in EU law since 2018, for instance. And it's also important to know that providers will also have to provide a certain amount of transparency to deployers as to how the system works. So deployers will be in a better position then to be able to assess risk before they deploy any AI systems themselves. It's also important to note that the Act stresses that you need to keep this impact assessment up to date. The technology is going to change rapidly and its application is going to change rapidly as well. So this has to be kept up to date. And when these safeguards or when the different uses of the system change, that also has to be included in any registration details with national authorities or with any of the EU bodies. So for instance, you will have many major AI system providers that will be providing the same system to many different public authorities nationwide in any particular country. So while it's very important that the providers should be giving general information to public authorities who will deploy those systems, the challenge will be that we don't have public authorities or any public-private partnerships that are just simply copying and pasting this general information on risk that they're getting from providers, because every organization is different. Every organization may use these AI systems differently. They may have different resources. They may have different numbers of staff. They may have different mechanisms for independent oversight. So it's very important that these fundamental rights impact assessments by the actual deployers of the system take into account that context, and also in terms of whether their uses of the AI system have changed or whether the risks in using that AI system has changed as well, or whether they're combining the use of that system with any other AI system, for instance. So it will all be about context and the detail of that specific application. So once the impact assessment is completed, deployers will also have to notify the Market Surveillance Authority, which is the domestic surveillance monitoring authority in every member state. And they'll be assisted in doing this using a template questionnaire from the EU AI Office, a body to be set up by the European Commission to help with these ex-ante regulatory requirements. And it's very important as well to acknowledge that we have lots of explicit requirements that data protection impact assessments, should be informing these systems and that they can be done in conjunction with them as well. Important that we see an acknowledgement here in the legislation that we already have related legislation in place that can assist public authorities, because there is an ever-increasing list of compliance obligations now for AI monitoring systems facing public authorities across the EU or anyone providing these systems to the EU. So the fact that this is a legal requirement places an added priority to fundamental rights impact assessments and data protection impact assessments above other, say, voluntary standards. It's also important to note that here we have another qualification, another caveat, that if there are deployers here that are using these AI systems for law enforcement measures, that when these details get added to that EU database, that they will not be publicly accessible. Some of those details for those systems by law enforcement will only be accessible to certain members of the European Commission. So there's the trade-off there between transparency and the confidentiality Oh, okay, not much time left. I might skip ahead on a few slides here and leave some questions for Q&A afterwards. So this is probably the most exciting image of a database I could find, but it's actually a very significant development that we will have an EU database that will have a list of these systems. And yes, we'll have some qualifications of how much information we can access in terms of law enforcement uses. But this is a very, very significant addition, a new important transparency safeguard we'll have in this EU database. I've already mentioned the differences and the way that data protection impact assessments and fundamental rights impact assessments will complement each other. Very important to note that they're not voluntary obligations. Very important to note that they are ex ante regulatory safeguards. They have to be done before a system is deployed. So we need to have safeguards that are embedded in the system. They both have a very similar threshold of high risk and significant harm to fundamental rights. So we don't have providers and deployers starting from scratch here. They should already have a lot of compliance and organizational experience dealing with these impact assessments. But what's very significant about fundamental rights impact assessments within the context of AI systems is that they're not limited to the processing of personal data, which has been considered a handicap for data protection impact assessments, particularly within the AI space. There's also an explicit focus in the legislation that the harms to groups be considered, that it's not just focused on individuals. So that's also another welcome addition under the AI legislation that we didn't previously have. But there is no piece of perfect legislation, and the EU AI Act falls very much within that scope as well. There are some very serious outstanding concerns still. As I mentioned, emotion recognition has not been banned outright. This is very much a red flag in terms of human rights protection, particularly from the perspective of legal certainty. The lack of an outright ban is very striking and disappointing. There are fundamental problems with this as an AI system to begin with, because the identification of emotions is not universal, it's highly subjective. Any of the independent research on these systems has shown that it's highly unreliable. It varies substantially between groups and different communities. And even within the recitals of the EU AI Act itself, it talks about serious concerns about scientific validity. So there are real questions here about how this can be considered proportionate under EU law, or how this can be considered fair use of data if the effectiveness of the systems is already in question. There are also questions of legal certainty, concerns about how the EU AI Act is going to work alongside existing pieces of legislation and the other new pieces of legislation that are now coming with the digital decade. There have been warning flags raised by regulators that just because a system has been given some level of conformity recognition within the EU AI Act, that unless some of the details of those conformity certifications are amended to also include the fact that, well, this has also been deemed compatible in terms of EU data protection law, that it shouldn't be taken as a carte blanche that this particular AI system, just because it's been considered to fall within the scope of the EU AI Act, is compatible with all different areas of EU law. But this comes back again to the complexity of the legislation, and we may have greater clarity on the Act itself once we have the official text in a few months. And then, of course, we have the very significant carve-outs for national security. These are incredibly broad in scope, and they've been the number of various concerns raised by EU regulators, the UN Rapporteur for Counterterrorism powers. And the clear concern here is that some of the most powerful AI systems that are going to be developed and are currently being developed will not be subject to all of these new novel safeguards under the EU AI Act. They're going to be left to the safeguards that are developed at the national level. And it's hard to see, given the encroachments now on the need to protect these rights within the national security sphere from the Court of Justice of the EU, how this could withstand not being amended in future or not be subject to a future legal challenge before the court. So very, very quickly, Chris, if I just have a second more to finish on a constructive note, there are achievements here for human rights protections under the EU AI Act that should not be dismissed. We now have a risk-based approach underpinning the AI Act. It's been welcomed by EU regulators because we don't want to have over-compliance in terms of SMEs, for instance. We want to have it proportionate to the intrusiveness of the AI system. The blind spot that we mentioned earlier on in terms of not taking into account any of the impacts on users in terms of rights and remedies and the recognition of the importance of fundamental rights protection and the importance of existing EU data protections, that blind spot has been addressed in the revisions, and that is very significant. We do have a clear acknowledgement now of fundamental rights protections under the EU AI Act that we didn't have in the 2021 proposal. And it's very important to know that deployers are also going to have to undertake fundamental rights impact assessments for some of the more powerful high-risk AI systems in future as well. That was a safeguard that is a complete novelty under EU AI, under EU law, and in the area of AI, it's going to be particularly important and will complement existing safeguards because it will also apply to areas where personal data may not be processed, but will be an AI system that can still very much impact people's rights and their freedoms and liberties. And I will finish there because I do believe my time is up. But thank you so much, everyone.